Yeah, welcome everybody. It's great to spend some time with you today. Not so great that we have to talk about a new law change that's going to put burdens on small business owners, but that's where we're at. The Corporate Transparency Act, Jess and I are going to go into this and really define it for you and help you understand it. But understand that from my perspective, it's a little bit of a different law change because it actually really applies to most small businesses where most law changes are applying to larger, bigger companies. But it's something that if you're on here and you own a business, you're in the right place. I know we also have attorneys on here who are learning about this for their own practices. Please know, as Kyle said, you are muted, but I'm happy if you unmute yourself and ask a question or put it into the chat. Jess and I are here today to help start talking about the Corporate Transparency Act and give information about it. Please know with any law change, what's happening is that the law ends up being passed, and then we see regulations that come out. And we're going to talk about the law, and already there's two new developments that I'm going to talk about. One's a court case, and one's a proposed regulation. And so, this is something that's fluid. So we're going to give you the best understanding that we have of it now, but there could be things that we don't know. Nobody knows. And so that's maybe the fun of new law changes, if you're like me and like this stuff, or the frustration of new law changes. But in this presentation, what we want to know, what we want to understand from our perspective is like, who does this apply to? Like, who needs to be doing this? Which of our clients, or if you're one of my clients, what does this apply to you? I'm hoping that you get that out today. Two, are there exemptions? And there are exemptions. And what we're going to see, Jess is going to go over those exemptions, but we're going to see that a lot of those exemptions are really for industries that are already highly regulated. So if you're not in an industry that's already highly regulated, the exemptions probably don't apply. And then honestly, what are your obligations? And just so you know, prior to doing this, I've already complied with this law for myself personally. And the obligations aren't really all that much unless philosophically you're kind of opposed to reporting to the government. And so you want to think about that. So for those of you who don't know me, as Kyle said, I am the founding shareholder of Steinbacher, Goodall, and Yurchak that has 6 locations across North Central Pennsylvania. Our firm focuses on anything that has to do with what happens if you die, what happens if you get sick, what should you be doing for the second half of life, and so really, I always consider it a privilege to be able to do what I do for a living, and really understand what it is that helps people moving forward. So, as many of you are aware, one of the things that I really like to do is to help people better understand and educate. And so there are books that I have co-authored or authored myself, of which we're always happy to give those to our clients. We have a Protect Your Family book, Don't Write a Blank Check to a Nursing Home, What You Really Need to Know for the Second Half of Life. Also, we have a whole series on dementia. So if any of those books interest you, you can always reach out to Kyle, and he can put his information. You can email him, and he'd be happy to send one of those books out to you. The other book that's in the picture is not a book that most of you would want. It is the Pennsylvania Trust Guide. So it is the guide that talks across the state of Pennsylvania. It's a handbook for trustees, advisors, attorneys. If you can't sleep at night, this is a book that you would want to read because it's very dry about trust law. I'm also a fellow of the American College of Trust and Estate Counsel. I'm very proud of having done that. For those of you who are my clients, understand that being an attorney from North Central Pennsylvania, it is hard to get elected because most of the attorneys are from Philadelphia and Pittsburgh. So it's a big city thing. And I'm so very happy that I was able to become a part of that, because actually I was just out in Phoenix last week and there's some fantastic programming. But it's one of those things that you have to get elected, yeah, and it makes it more difficult. I know that when I was just out in Phoenix, I was the only attorney that was there from not a big city. And actually, when I was at one of the meetings, I suggested that they needed more rural attorneys, that we would bring our own diversity, and particularly farm planning and those types of things. So I also have an advanced degree in estate and elder law. So I have an LLM. I actually crazily went back to school more recently at night and really kind of updated my knowledge. So as you can see, I really love what I do, and that comes out in all the things that I've been able to do across my career. I'm going to hand it over now to Jess to introduce herself and talk about the first part of the law. So Jess is one of our younger associates at our firm who will tell you that she considers herself extremely lucky that she gets to work with me. It's not.
I am, Julie, I am. So, hi everyone, I'm Jessica Eckrote. I am one of the newer associate attorneys at Steinbacher, Goodall and Yurchek. I work in estate planning and wealth protection planning. I myself am very excited to be here, but I think my parents might be even more excited than me because now they finally get to get their estate planning documents in place. I just graduated this past spring from Widener University Commonwealth Law School. And before that, I went to the University of Pittsburgh to get my bachelor's degree. So let's dive into the Corporate Transparency Act now. So I'm sure a lot of you are wondering, what exactly is the Corporate Transparency Act? So the Corporate Transparency Act was enacted in 2021, and it just became effective in January of this year. Its purpose is to try and limit money laundering, tax evasion, and that kind of criminal activity. It tries to monitor smaller businesses to see if they're serving as a shell company or an entity that could be a vehicle for criminal activity. And this act really gets into the weeds of who exactly owns a small business, as well as who's a part of these smaller businesses by requiring them to report personal information. And I'm sure you're all wondering as well, who is going to be affected by this, because you're wondering if you are going to be affected. So primarily it's going to be small businesses, specifically non-employer firms. This is going to affect many people across the country. It's estimated that 32 million businesses are going to be affected by this act. Who's required to file under the Corporate Transparency Act? So entities that are created by filing paperwork with the Department of State are going to be required to file. There are two types of recording companies. There are the domestic reporting companies, which are your LLCs, your corporations, and any other entities that's required by filing with the Secretary of State or a similar office. And then for the foreign reporting companies, these are entities that are formed under a law of a foreign country that are currently registered to do business in the United States. And they have also filed a document with the Secretary of State or a similar office to do so. Now, some statutory trusts and business trusts are going to be affected by the Corporate Transparency Act. So these entities have to comply, again, if they file a document with the Secretary of State. So that's kind of going to be the guiding principle. If you filed, then you should definitely be checking out the Corporate Transparency Act to see if your trust falls under it.
Yeah, and I'll just add there that those people who are from Pennsylvania, typically we don't file our trust under the state law. Like we don't file it with the Secretary of State. So typically that's not going to. I will tell you though, that doesn't mean that you're out of the weeds with a trust. And we'll get into that more.
Now, FinCEN has stated that there are exemptions to the filing requirement. There are 23 different types of entities that are exempt from the beneficial ownership reporting requirements. These entities include publicly traded companies that meet specific requirements, many nonprofits, and certain large operating companies. So please bear with me while I go through the exemptions with you. As Julie mentioned before, you're going to find that the entities that are exempt are in areas that have their own regulations in place. So we have securities reporting issuers, government authorities, banks, credit unions, depository institution holding companies, money service businesses, broker or dealers and services, securities exchange or clearing agencies, other Exchange Act registered entities, investment companies or investment advisors, venture capital fundraisers, insurance companies, state licensed insurance producers, Commodity Exchange Act registered entities, accounting firms, public utilities. This is the last exemption slide, I promise. Financial market utilities, pooled investment vehicles, tax exempt entities, entities assisting a tax exempt entity, large operating companies subsidiaries of certain exempt entities, and inactive entities. And I'm just going to touch briefly on what exactly inactive entities are and what their requirements are for an inactive entity under FinCEN to be exempt. So in order to be an active entity, it had to have existed before January 1st, 2020. It is currently not engaged in any active business. It is not owned by a foreign person. There has not been a change in ownership in the preceding 12 months. It has not sent or received funds greater than $1,000 in the preceding 12 months, and it does not hold any assets.
Yeah, and I'll just add a couple of things there. So fantastic, Jess, as you are talking about inactive entities, and this has a real impact, because many times when people pass away, nobody closes up the business. They don't make it inactive. They don't take it down. They don't, what we call in Pennsylvania, dissolve it. And this is going to be a real big deal. Like, you're going to have to dissolve these entities when you stop using them. Otherwise, you're going to have these FinCEN regulations. You always should have, but it's going to add to that. The other thing is, like, listen, I know there are attorneys on here. You know, what's not exempt? Law offices. So those of you who know me know that I have a little bit of a, ticks me off. So accounting firms aren't, don't have to comply. Financial advisors who have licenses don't have to comply, but attorneys do. I feel like I'm just as regulated as those industries are. But I have to tell everybody, this is just a little bit of a holdover that during COVID, the state of Pennsylvania said I wasn't essential. I did appeal that with the state of Pennsylvania and was able to continue working, because I do feel like what I do is essential. I feel like when somebody's diagnosed with cancer and they're about to die, me going to the hospital and helping them with their estate plan is highly essential. But I'll get off my bandwagon because nobody else cares how I feel about this. But I just think it's interesting to note.
So what is the Corporate Transparency Act meant to achieve? I touched on this a bit in the beginning. It's intended to help law enforcement agencies prosecute and deter money laundering, tax fraud, and other fraudulent activities. Now, you're all probably wondering how these goals are going to be achieved. It's by requiring covered companies to file reports with FinCEN about the company itself, its beneficial owners, and its company applicants.
Yeah, and I'll start talking about beneficial owners. So we're going to now kind of move into the reporting. So far, what Jess has talked to you guys about is that there's the Corporate Transparency Act. And the reality of it is every small business has to comply with this unless there's an exemption. And there are exemptions for like larger companies. And, we're not getting into that because, most of the people, either if you're an attorney on here that you serve, or my clients that, would be not considered one of those larger companies. If anybody has any questions specifically about that, I'd be happy to get into that. But we're now gonna kind of switch to, all right, so the company has to comply. So what does that really mean? And the people who have to report is anybody who's a beneficial owner. And how do we know what a beneficial owner is? It's an individual who exercises substantial control or who owns or controls at least 25%. And so I think very importantly here is it's not just an owner. A beneficial owner is either somebody who does own the company, over 25% of it, or in some ways controls it. And we'll talk about who is, who has substantial control. So a senior officer, so somebody who is really integral to that business, an individual who has authority to appoint or remove certain officers, important decision makers, any other form of substantial control. And you love that with the government. That's just the statute, and then there'll be regulations that will say, what does that really mean? But one of the things that we already kind of think about, or I think about as soon as I read this, is a trustee. A trustee of a trust clearly has substantial control. A trust advisor in a trust document clearly has substantial control. A trust protector could have substantial control. And so I think that, in the estate planning world, we're going to be pulling a lot of people into this. Now, again, we have to underline, does that trust own a business? In some states, that's what's going to click it. In some states, the trust itself is going to click it. So, so important. Ownership interest. So it's either a substantial control or I have an ownership interest of 25%. But again, we're kind of looking at like, what does that really mean to have an ownership interest? Clearly, it could be shares of stock, it could be equity, a partnership interest, an LLC interest, but we're also looking at things like voting rights, other types of ownership control that establishes ownership rights. And so that could be like if we're, let's say, you own a small business and you're selling it out, but you retain certain powers, maybe because you're financing it, that's going to have you still have an ownership interest. And that's going to be important because then you're going to have to continue doing this reporting with FinCEN. And so I think it's important that people think about that, moving forward as they go through this. So what we know is it's small businesses, anybody who owns it or has any type of control over it. So we know that there's a broad definition. So let's say that we're.
And Julie, isn't a question in the chat, isn't the constitutionality of this law being tested?
It is. Actually, that's later on in my slides, but I'll talk about that now. So there was a court case that we'll get into that found this to be unconstitutional. Now, understand that it was not like the U.S. Supreme Court, but within one of the appellate courts kind of going up. And I'll talk about it more specifically when we get to that slide. Understand, though, if you're in that circuit, that jurisdiction, you could have say that I'm not going to comply with it because the law within my area, it does not apply to the whole U.S. The other thing I will tell you is that FinCEN has already come out with the fact that they say they don't agree with that law. And I know that ruling. And I know as an attorney, I would say, well, you can't just ignore, a judge's order. We have this, breakdown of power as far as, the judicial branch and the executive branch. And if the judicial branch says it's unconstitutional, it's void. But we have this agency who's saying, yeah, but we don't care. We don't agree with that ruling until it goes the whole way up to the U.S. Supreme Court. And so it's going to be interesting to find out where that goes. My recommendation to people is to still comply, and we'll talk about this later, but the reason my recommendation is because the penalties are so big. And so, we're talking about a penalty of $500 a day, 2 years of imprisonment. But again, that's where, so just so you know, the reason that it was struck down is to say this is an invasion kind of our privacy. And that's a great segue into what we're going to talk about, because we have to ask, what is it that they're actually asking us for? So great question is a great segue into the next slide, which is, okay, if this law applies to me, what do I actually have to do? So we have a court that says, oh, this is too much. But what you have to do is you have to report your name, your date of birth, your residential address, and then an identifier number. And that's a number like your passport number or your driver's license number. It's some number that goes with an identifying document. And so like in my situation, when I did it, I uploaded my driver's license. My husband and I own some real estate together, so we had to upload his driver's license. But this is what you have to do. So this is what the court kind of struck down and said it's unconstitutional. They're asking me for too much information. Now, please understand, like I know philosophically, some people may say this is an invasion of privacy. But it's interesting to me, I can't get somebody's EIN number. Like if you came to me and you asked me to set up a new business for you, I need this information. In fact, I need more. I need your social security number. So in order for me through the IRS to get an EIN number for you. So for me, I'm definitely have my thoughts about government invasion and privacy, but this is something that for a business owner, I'm already really reporting these things to set up a business. we're also really reporting most of this stuff on our tax returns. So it's interesting to me, and I don't know how that court case will pan out. And the person who asked that question, if you know anything more about it, I'd love to have, you're welcome to put in the chat. And particularly when we get to that slide, we'll talk about it again. And if you have any thoughts, I'd love to hear them. But that is an important thing, and you see this. The other thing that you have to understand is no matter how people feel typically about privacy and having to report to the government, just so you know, the US is one of the last states to comply with this. This is much more about internationally looking at terrorist and money laundering. And so there's also a public policy argument behind all of this. For me, the biggest concern I have about this law is that it's asking really small businesses to comply with it. And I think there should have been an exemption for somebody who maybe has a hobby, but maybe a small working farm that really isn't, I can think of like representing two brothers that own a farm. I think there should have been some bottom exemption. That's my opinion. But again, none of us have a lot of experience with this law, and it's something that we're moving forward to learn more about. The other thing that has to comply with it is a company applicant. That's the person that created the entity or first registered it to do business, and therefore is responsible for directing or controlling the filing. Now, I have to tell you, if you're an attorney on here, this was scary when I read this, because I feel like as an attorney who helps people set up businesses, that I'm a company applicant. So it's interesting when I read it, it's that I help them fill out the information, and then I directed it. And I do that. I help them fill it out, and then I send it to our state, enclose the check, do all the other paperwork, or I send it to a corporate service that then gets it done, particularly if I want it done fast. And so please understand, this also could be the original incorporator. So sometimes we start a business and 4 people own it, but only one person signed that original application. And so that's a little bit, I think it's important for us to know. So what do we have to report about the company? Its legal name, any trade businesses, any trade names. So like my office is called Steinbacher, Goodall, and Yurchak, but it actually, the real name of it is Steinbacher Law PC, and it's just doing business as Steinbacher, Goodall, and Yurchak. So a lot of companies have used different names over the years and have registered them as doing business as. Current street address of its principal place of business, and its taxpayer ID number is what I need to report then. So again, I've already kind of talked about this. Is my attorney a company applicant? The best attorney answer for stuff like that is it depends, which really is no answer at all. But I already kind of talked about the fact that a company applicant could be the person who helped form the entity. And basically what the law says there, I prepared the filing and directed the creation by using a service provider. So I do that. So at my office, I would have to go back and look at all of the businesses I've helped create, and I would definitely be a company applicant in this situation. But moving forward from there, I think of any trust that I'm as a trust advisor in, which we do that as a service to our clients. We don't charge for it, but we do it so that, let's say I set up a trust and it's going on the generations, and the person who originally created the trust, maybe they've passed away, or they have, they're incompetent, they're not able to make their own decisions, and the law changes and the trust needs to change. Instead of my clients having to go to court, I, as the trust advisor, can step in and make those changes. Like I can't make changes like changing who the beneficial interest is, like changing who gets the stuff. But a great example of this, where I did a lot of it, was when I had creating a lot of trusts, and I had, so As an example, I have 3 kids, so I used to use what was called a common pot trust, so that if I passed away, my 3 kids used that same common pot, that trust. So I had one trust for all 3 kids that they could benefit from. And then the Affordable Care Act came and added an extra tax, and it made it more beneficial so that in my situation, Courtney would have her own trust, DJ would have his own trust, and Stephanie would have her own trust. And that's just a small change. It doesn't harm them in any way. It made a big difference in the tax law. And so in that situation, obviously I could still change my own trust, but I had clients who had passed away or had dementia and Alzheimer's to such a significant extent that they weren't able to execute new documents. And as a trust advisor, I could come in. So just to kind of give everybody an idea of like what that is and why, I would be doing that, it's really a service to my clients. But in that situation, I think that makes me have to comply with this law because I have substantial control over it. So even though I can't change like who the beneficiaries are or undo anything that my original clients wanted, I just can help it change with the changing laws without having to go to court to save my clients money. So that's an example of that. And I think that that's really important for people to be understanding. And I know that there are some attorneys on here that, like me, offer to do that for clients as a service to be beneficial. And I think that puts us on the hook from this perspective.
Do you think that it matters whether the trust protector or trust advisor is fiduciary or non-fiduciary?
Now, that's a great question, Nathan. That's a great question. And that's where, like, I would think, like, if I was a fiduciary, why should I have to comply with this law? Because I'm already regulated. But no, I don't think it matters. I haven't read anything. And please know there could be regulations coming out. But so far, everything that I've read, I don't think it matters. I at my office, I work in a non-fiduciary capacity as a trust advisor.
Yeah, so do we.
Yeah. So what are the filing deadlines? So if your company was in existence before January 1st of 2024, so you had a company from 1999 or 1990 or 2023, so you, like me, already have existing businesses, you have until January 1st of 2025 to comply with this law. Now I've already complied, partly because I wanted to figure out how difficult this is. What do you have to do? And I would say to you that when we complied, it's the old, so FinCEN, FINCEN, that we're talking about. If you get on that website, so right away you have to make a password and, like an account, right? And so I get on to do it myself. And of course it already has an account with my email. And I'm like, so what the heck is the password? So that was probably the hardest part of it, was like figuring out why did I already have a password, when did I had used this, and how that was. So we got through that. And then it doesn't really take a lot to comply. We have to upload the documents. Now I say that, I say isn't all that difficult. That's because, me and my staff that were doing it feel comfortable with computers, uploading things, those types of things. So if you don't feel comfortable with that, that could be a little bit different. At our office, we are trying to get the word out to our clients that this is required, and we will help you at whatever level you want help. So the other day I was meeting with a business owner. She owns a couple of different businesses. I was talking to her about it. She had no idea about this. And in that situation, I told her my experience, what to do. I felt like she was a person that could probably go do it herself. But I said, if you have any problems, come back to us. Trisha, my paralegal, will sit with you and help you do this. We also have a lot of clients that we're going to have to do it for them. Maybe, when we get into trust, and maybe the individuals are not business savvy, not computer savvy. And so, we want to be able to do that. And there's some issues with, setting up that password, that account. We don't want those set up in our emails. We want them set up so that our clients have access to them. But what I would say to you is, I know people say, oh, Julie, January 1st of 2025, I don't have to do anything. Well, guess what? if you wait and call me in December, we're going to be too busy, right? So we really want people to start doing this about May of this year, contacting our office, making an appointment, kind of going through it, figuring out what's best for you, or trying it on your own. And Sean Anderson at our office is going to be able to be available to help anybody who needs help with this. And our goal is really to help you make sure you know how to do it and that you've complied. And if there's any questions about who has to report or what has to report, that we're able to deal with that. So I urge people not to wait until December. Please don't do that to my December. Please start dealing with it now. Now, if you're a person who says, you know what, I don't want to comply with this law, Julie, I think it's an invasion of my privacy, and I'm going to wait what happens with this court case. That's your absolute, right to do that. If a company is created in 2024, so if I open a new business this year, I've already done this, we have 90 days to comply. And the biggest thing there, like the one I just did recently, there's 5 owners. I need to get all their driver's license. If it's a trust, I don't know about you, but sometimes, for those of you who are my clients, I love all of your kids. They're always just not as compliant as which I would like them to be. And so sometimes gathering information from, 6 or 7 people becomes more difficult. After January 1st, 2025, you have 30 days to comply. And just so you know, if you thought that in 2024 you had 30 days to comply, that was what it said, but they've made a change already, giving 90 days. And I actually think 90 days, I think that 30 days is going to be pretty hard to comply with, unless you're kind of really make it part of your procedure. I think 30 days is a short amount of time. I know, like, for other things we have to do for IRS, like a subchapter S election and stuff, we usually have 90 days. But at our office, we've just made that part of our procedure. The other thing I'm kind of surprised about as far as these filing deadlines, from what I have read, unless it has changed at all, this is not something that CPAs and accounting firms are getting into. In fact, the national guidance from AICPA may be that this is not something that we want you to be doing. And I'm not exactly sure why, but it's interesting to me that I have clients who, are not hearing this from their accountants. And I had originally thought that maybe that would be where they would, and that this could be something that could be put on with, I file your tax returns, I'm just going to file your FinCEN at the same time. But that doesn't seem to be the way that it's shaking out. There's also 30 days to file an initial beneficial ownership report that gets springed up. And that's like the initial report after the business. And again, this is assuming not the special exemptions that I talked about, like prior businesses, but just what the obligations are going forward. You also have to update the obligations. And that's 30 days from the date of the report of the change. So if I gifted to a child, if I did a succession plan, if a child bought 12% or was gifted 12%, or a new owner, I have to report those within 30 days of that ownership change happening. So again, at my office, we do a lot of gifting. We do a lot of business buyouts, succession planning. And so this is something that's going to have to be added to our checklist of things that need to be updated and done. Difference, and again, I think this is really important because technically in my state, you always had to report to the state Department of State when the officers changed in a corporation or when an ownership changed. But often I have people who come to me kind of late in life doing their estate planning, and they somewhere have done some business succession planning and nobody reported to the Department of State. And there's not really like a penalty for not doing it. But remember, and we'll get into this, there's huge penalties here, which I, think is important. That's why this is worth our time thinking about. The other thing, for those of you who, feel like I'm drowning you out a little bit, you're not paying attention, or you're halfway paying attention, this next slide, you definitely want to pay attention to, particularly if you are an attorney on here. There is a proposed regulation. So proposed regulation means it hasn't been passed yet. What happens February 16th, there's a proposed regulation to this legislation. And then what will happen is there'll be 60 days to comment on that. So I, as an attorney, could comment and say, I don't agree with this, or this is going to be difficult, or, you know, this is going to add to the cost to my clients. I could comment, pro, con, whatever. And then after 60 days, usually what happens with regulations is they become law. They might change a little bit based on the regulation, but generally remember that the person proposing the regulations is the agency that probably wants this to happen. So they're saying non-finance transfers of residential real estate, including transfers by gift or note, into revocable or irrevocable trusts, into other entities such as LLCs, are going to have to be reported. So this is a huge expansion of FinCEN. So it's interesting that at one point in time we have a law that's putting this down as unconstitutional, and we have an agency that's really, I think, expanding the definition and powers of this. Similar to the Corporate Transparency Act reporting requirements, certain information about the owners of a transferee trust or entity would need to be reported to FinCEN within 30 days of the transfers. And it's the lawyer who created the deed that's likely to be the person required to report. So really important here. So it's always interesting to me. I still have people where I live that like say, oh, you know, you charge too much to do a deed. You know, doing deeds requires a lot of work. One, I need to know, is the deed prior to it any good? Like, so I do some extra work in looking at the title. Is it the deed prior to it any good? Next, when I do the deed, then I also have to report it to the state for realty transfer tax and make sure there's an exemption. I often have to report it depending on the municipality. So those of you who are from Pennsylvania, this will make sense to you. From those of you who are not from Pennsylvania, will think we're a little crazy, but we have to report it both to our county and to our local little township often. And if you talk about an invasion of privacy, that's the one I'm afraid of. I'm sick of having to tell my neighbors, you know, what's happening, but the county and then local. And then this is going to be an extra thing along with any programs like Clean and Green or any other type of programs. So again, I want to stress that this is not law yet. It is a proposed regulation, but proposed regulations are likely to go through, if anything, just be amended. But that's something I'll be watching and find out 60 days from now where this is at. And so this would be even if you were just doing an outright gift to your kids. There's a question of that. And so or revocable, irrevocable trust entities such as LLCs. So we want to really be thinking about that. So what happens? I've alluded to this twice, kind of opened a loop for you. What happens if you don't comply? What happens if you say, I'm not telling the government that stuff, right? Well, the fines are $500 a day. A lot of money for a little business, right? 2 years of imprisonment and a fine of $10,000. They're the max of it. That's a lot. And so again, where you come down with, what would you, if you're an attorney on here, advise your clients to do based on the case law, that you're going to have to figure that out. So the case that was alluded to comes out of the Northern District Court of Alabama. And they ruled that the Corporate Transparency Act is unconstitutional on grounds that it exceeds Congress's legislative powers. With a 90-day filing deadline approaching at the end of March, it seems probable that the government will appeal it and request a stay or an injunction. To my knowledge, I don't know that that's been done. I haven't read that, but they request a stay. A stay means that like you stay it so that it doesn't like we have to wait for the next lawsuit to have any kind of change. To announce a further delay in reporting deadlines, prevent inconsistent enforcement issues. And so we'll be thinking about, where are we at with that? And I think that we will have new developments with that, moving forward. And I did not Google it right before getting on. I don't know if anybody knows if it's been appealed. I have not seen it be appealed. So So I think everybody really does need to take action on this. For those of you who are attorneys on here listening to me, I think you need a proactive approach now so you can respond to clients' inquiries quickly. So you need to make a decision. Is your firm doing anything with this, or are they not? And if they're not, who are they sending your clients to that rely on you? If you are, I think you need to then talk about, well, what is your scope of engagement? What are you going to do for them? And who at your office is going to do that? So organize the system. So at our office, we've spent a good amount of time trying to figure this out. And actually this seminar today is part of that, because we're trying to get on this call is some of our clients that we're trying to let them know, hey, this could affect you. And we want you to know about it. And some people could get off of this webinar and go do it themselves. And I'm okay with that. And some of them may say, oh, gosh, I really want to talk to Julie more about this in my specific situation, or somebody on her team. And that's okay too. And that's why we're starting this now, not later on. And it's also why, I'm not going to wait until we find out more about this case, unless we find out that, it's considered unenforceable right now or pushed back in some way. So I think that's really important. And I don't think some of you on here may decide not to get involved at all. And I think that's okay. Just really kind of watch those regulations about deeds, any residential real estate that's being transferred. Just so you know, the reason behind that is they feel like a lot of money is laundered through real estate. That's why it's there. So again, we can have this whole thing of, well, this shouldn't be this way, but it's an attempt to crack down on money laundering. And unfortunately, residential real estate is a huge part of that. I also think it's interesting that, as we saw, some of the exemptions are for people selling financial products, and yet life insurance is also a huge place where people money launder. But that isn't. For those of you who are my clients, potential clients on here, one of the things you have to think about, is your business ready? You're welcome to go right on FinCEN yourself, try to figure it out. You also can call our office for assistance. You can visit our website, send an email to info@PA Elder Council. You can call our office. Happy to help you. Understand that if you called right now, they may be making your appointment in May of this year. That's kind of when we really kind of want to kick this off. And deal with people. You are better to be dealt with earlier versus, again, I can't stress enough, please do not ruin my holidays. I have to say, you won't be ruining mine, you'll be ruining my support staff. No, I'm just joking with you guys. And thanks, Kyle, for putting into the chat that link. And please know, I think this is difficult. Even if you do it and you want us to look at, did you do it right? Did you do it correctly? We also am happy to help you just by you coming in the office and doing it with one of my staff. We just want you to kind of understand it. And we feel like our role is to help you understand it and help you be able to do it yourself. It's not something that I'm trying to, make money off of you in any way that oh, you have to have my office do it every single year. Just like we do at our office with annual meetings. I think it's extremely important that businesses have annual meetings. My prior life, before being an LLC estate planning attorney, I did litigate. And I often was trying to pierce the corporate veil. And the first time, the best way to do that is to ask somebody, where's your corporate book? And have you had your corporate meetings? If you haven't, I'm going to have to be able to go after you personally. So just like in our office, we'll often show you how to do it. We'll give you the forms. We may remind you to do it. But our job is just to kind of help you figure out how to do it. We also are very happy. Some people, I have owners who say, listen, Julie, it's not worth my time. You have a great system. You guys can do it quickly. I just want you to do it. And so you'll have to decide where you are in that. Don't forget that we are here to help you. Stay connected to us. We'd love it if you like us on Facebook, subscribe to our YouTube channel, listen to our Second Half of Life podcast. This will be on that Second Half of Life podcast. There's also plenty of other great information on there. If you have any questions, about other parts of the law.